Okay, so I am Laura Akins. Like I said, I'm with a firm called Nadiler, Biernath. Here's a little picture of some of our folks on the front, and of course today we're talking about estate recovery. Okay, Nadiler Biernath is a full-service estate planning law firm, but we specialize in elder law and special needs planning, and that's kind of a neat thing. It's a little bit of a niche in that not very many people do it. And what we're doing when I say we specialize in special needs planning and elder law, a lot of people aren't even really familiar with the fact that there are law firms that do this. And what we do is we're planning for folks with disabilities, planning for families who have family members with disabilities, and also just for people who are aging and want to make sure they can maximize their benefits, and also still be cared for in the long-term process that, you know, people are living a long time now. So that's what we do at Nadiler Biernath. A little bit of a disclosure before we really jump in today. This is going to be an educational presentation. I hope you get a lot of information from it, but it should not be construed as legal advice. And if you think, you know, some of this is interesting or you need to pursue it, I'd highly recommend getting legal advice before doing too much more. Okay, so we're talking about Medicaid and estate recovery today. And so in order to really understand estate recovery, it's important to understand how it applies and what programs it apply to. When we're working with our sort of benefits in general, we're usually talking about Social Security, Medicare, and Medicaid. Okay, and so the estate recovery component that people are always thinking, I don't want the government to take my house or whatever, that's going to be applied to Medicaid. Okay, and so it's important to understand what Medicaid is. Medicaid is a means-tested health insurance program funded by federal and state governments. Means tested there really just means literally how much money do you have. Medicaid cares very much how much assets and how much income you have. In order to be eligible for Medicaid, the beneficiary is going to have to be aged, blind, disabled, the parent of a minor child, and then of course their income and resources have to be below a certain threshold. I'm in Georgia, and so I'm going to be talking about Georgia Medicaid today. It's important to understand that Medicaid programs vary by state. Sometimes they vary a little more or a little less, but because they're state and federally funded programs, the states are going to be dictating a lot of the terms of the Medicaid law. So it's important to know that today we're talking about Georgia and Georgia's estate recovery. When you're receiving Medicaid, the beneficiary is going to have to fall within a defined class of assistance. I've also gotten their COA to be eligible for Medicaid. So for those of you that are familiar with the military, you know they use all of the acronyms and all that stuff. So does Medicaid. So Medicaid often refers to things as COA instead of class of assistance. And what that really means is just what kind of Medicaid are you receiving? And so in Georgia, we have, just like many states, we have many COAs, and they all have various financial eligibility criteria. And very importantly, not all Medicaid programs in Georgia have estate recovery. Okay, so you could be receiving Medicaid and not be eligible or subject to estate recovery. Important to kind of know there. Okay, so when we say estate recovery, what does that even really mean, right? So estate recovery applies to COAs or classes of assistance that, oops, too fast. They apply to estate recovery or I'm flipping through. What is estate recovery? And so we're talking about COAs that provide long-term care and home and community-based services provided through Medicaid. What that really means, that translates to nursing home Medicaid and waiver programs like the ICWP program, now in comp waivers, programs that are providing home and community-based services. And so after the death of the beneficiary, Medicaid is going to seek reimbursement of funds paid out for that beneficiary. There's a lot of caveats to this that we'll kind of get to in the presentation, but these are the basics of it. This is kind of how it works. If you're receiving these Medicaid benefits, then when you pass away, Medicaid's going to say, okay, we spent a bunch of money on you, so now we'd like to get paid back. Medicaid Estate Recovery as a program overall in Georgia became effective on May 3rd, 2006. So if for some reason you were dealing with someone who passed away prior to 2006, then you would not be subject to estate recovery, but anybody after 2006, it kicks in. Okay, so why is Medicaid doing estate recovery? I think this is something people just want to know because it seems so unfair, frankly. And I have a kind of a one-line answer here because it's the simple answer. Medicaid is spending a lot of money on these programs that have estate recovery attached to them. And so it's an attempt to kind of recoup some of those costs and continue the Medicaid programming. That said, there's a lot of drama or people disagree with that logic because often the estate recovery program just doesn't recover. People who are on Medicaid generally don't have a huge amount of money. So estate recovery is not a particularly profitable program. So just something to kind of be aware of. Okay, so a lot of people want to know, how do I know if my class of assistance is going to be subject to estate recovery? So this is a super important point here because, and in the title of the presentation, it says, did I sign that form? And that is the answer to this question. When you're applying for Medicaid benefits, the applicant is technically going to receive notice of estate recovery by a form that's included in the application for benefits. After the fact, after a person has been receiving benefits, if their estate is subject to recovery, Medicaid has to be able to produce that form that the person signed because the signature is saying, okay, I agree, I want these benefits, I agree to estate recovery. So if they can't say this person knew what they were jumping into and they knew that their estate was going to be subject to recovery, we can't recover. We've had some people have some success in not being subject to estate recovery because Medicaid doesn't get its act together. Medicaid is picking up on this. They're starting to learn that they need to have this form. So it's less common now that that's an issue, but very much something to be aware of. If you are either yourself dealing with estate recovery or you could be subject to estate recovery, you want to tell your family, make sure they produce that form. Okay, so the next slide is which classes of assistance does estate recovery apply to? We talked about this a little bit, but I want to be a little clearer. So in general, the estate recovery program is going to apply to nursing home Medicaid. So regardless of age that you go into a nursing home, if you're receiving nursing home Medicaid, then you are going to be subject to estate recovery. And again, in Georgia, nursing home Medicaid is going to be a program that pays for care with a person living in a nursing home. It doesn't pay for assisted living or other kind of, it's purely skilled nursing facilities. So that's what nursing home Medicaid is. Estate recovery can apply to classes of assistance providing those home and community-based services through a waiver program. But the key is that it only applies after age 55. So it only applies to the care and expenses put out after age 55 if a person is receiving benefits under one of those waiver programs. That's actually a pretty important point because many people are receiving benefits under those waiver programs and they're not 55. And so that is not subject to estate recovery. Okay, so when Medicaid gets or is trying to get money through estate recovery, what are they trying to recover? And what they're trying to recover is the total amount of funds spent on the person post age 55 in some cases for basically all of their health care and related health expenses. Again, most people receiving Medicaid are not going to have a ton of money. And usually, oftentimes, their primary asset is a home. But even then, you're not going to be able to pay for all of the care that you receive. Let's say you're living in a nursing home for 10 years. That's quite expensive, for better or worse in our society. So that's what Medicaid is trying to recover. But the bottom line is they can only recover from a person's estate. So they're just going to get as much as they can based on what's going on. Okay, so then the question becomes, how does Medicaid define estate? Okay, and Medicaid defines estate very differently than the law does. And in fact, there's a fair amount of confusion among people about what really qualifies as estate funds for purposes of Medicaid, because under the law, we have property law. So we say if a bank account is jointly owned by two people, then upon the death of the first person, that person goes away. And so that bank account is just owned by the second. It doesn't go into the first person's estate, right? It just automatically passes to the second person. So that's kind of what we say happens to that joint bank account. But for purposes of Medicaid, actually that joint bank account is going to be subject to estate recovery. Okay, so when we're asking what the estate is, there's really two questions. It's what property did the decedent own, the person who was receiving Medicaid, and is that property interest a part of their estate? And so the bottom line is, if a person's name was on an asset, be it a home, a bank account, a lot of the basic trusts, and you can see I've got in there at the last line there, the estate will also include property passing by joint tenancy, right of survivorship, trust, with some caveats, because there are some caveats to the trust. That's all going to be subject to estate recovery. A lot of people think if they title a home with joint tenant with right of survivorship, that they can avoid it, because again, normally it automatically passes to the surviving owner because it says with right of survivorship. But for purposes of Medicaid, it's still going to be in the decedent's name, that the half interest. Okay, so that's how we define estate, is all of those different things. Importantly, and this is a good development, as of July 1st, 2018, Medicaid is waiving estate recovery claims for the first $25,000 of any estate. Okay, so what that means is that if a person passes away with an estate that's valued at $25,000 or less, regardless of the services that they were receiving under Medicaid, they will not be subject to estate recovery. If a person passes away with an estate valued around $26,000, then $1,000 of their estate is going to be subject to estate recovery. So it's kind of silly, but that's the case. Now, will Medicaid pursue that $1,000? I don't know. They might, but that's just an example. So anytime you've got an estate valued at $25,000, you automatically get the $25,000. It's just anything beyond that. That's after July 1st, 2018. So for folks who passed away before July 1st, 2018, that's not going to be in effect. It's only for those who pass away after July 1st, 2018. Okay, so when we're talking about the actual process of recovery, what does that look like? And so when a person who's receiving Medicaid, that is a class of assistance subject to estate recovery, then that person's either their personal representative, an agent, an executor, somebody has to notify Medicaid that the person has passed away. Once Medicaid has that notification, they will submit to whoever sent the notification in, probably. They have to submit written notice stating the terms of the recovery. That's going to be basically an accounting of what should be recovered, and then some hey, by the ways. So they're going to say you are subject to, you can submit a claim of undue hardship and say you want to waive the estate recovery. They're going to say that you can have a hearing if you disagree with the amount that they give you. They're going to give you a bunch of things to say, here's all your rights, basically. It's important to note that if the deceased Medicaid recipient had a spouse, child under 21 years old, or a disabled child of any age, Medicaid cannot immediately initiate the recovery. That kind of manifests a little bit differently depending on the assets, but bottom line is if any of those things apply, Medicaid will push back or defer recovery. They won't end it, right? So we're not that lucky, unfortunately. They'll pay attention to the spouse's life. So when the spouse passes away, that would kick it in. When a child turns 21, that would kick it in. Or when the disabled child passes away, that would kick it in, right? So you can kind of defer, and that's a good thing because, of course, we want all of these folks to be supported and not have to give up everything to Medicaid necessarily, but nonetheless, it's worth kind of knowing. And then the other thing to know is that Medicaid must seek reimbursement from all other available sources, including, I've got, for example, D4A. D4A is a first party special needs trust, which we'll talk about in just a minute here, but they have to seek reimbursement from all other sources before utilizing estate recovery. Okay, so they can't just say, take the easy route and say, here's some available money to us. I was just looking at the questions here. Somebody asked, the question is, so Medicaid recovery starts for anyone who receives a Medicaid waiver after 2006. And basically the answer is yes, but again, with the caveats of they have to be over the age of 55 in order for if it's a waiver program for estate recovery to kick in. Okay. So I mentioned the undue hardship that Medicaid went in that letter notifying you that you're subject to estate recovery. You can file a request a waiver for undue hardship. It's pretty hard to get, unfortunately. So, but what is undue hardship? An undue hardship waiver can be granted if the first one is if the asset to be recovered is an income producing farm that belongs to one or more of the heirs of the Medicaid beneficiary, and the annual income is limited to $25,000 or less. So that may apply to some folks, but you never know. I don't think that's going to apply to a lot of the people that may be receiving Medicaid. The next one is more common. So the other reason why they would grant an undue hardship and you could potentially waive estate recovery is if recovery of the assets would result in the applicant for the hardship waiver becoming eligible for public benefits. Okay, so if because Medicaid is initiating estate recovery, it creates a situation where the surviving person is going to have to apply for benefits, maybe because they don't have a house or whatever, then you could potentially get an undue hardship waiver in that case. Okay, so everybody always asks about the home because many of the circumstances around estate recovery are that a person needs to go into a nursing home or they otherwise can't live in the home, but they have a house. And if you have one house, it's considered a home place. And so it's an exempt resource when we're looking at eligibility for many of the benefits under Medicaid, okay? So in a home, not a rental property, not a business property, but a home place is owned by a Medicaid beneficiary, it's exempt. That's lovely until we get to start talking about estate recovery, because if it stays in the person's home, in the person's name, the Medicaid beneficiary's name, then it's subject to estate recovery when they pass away. So the way that works is that if a Medicaid beneficiary has an interest in property, Medicaid will place a lien on the title to the home. And so that can work a couple different ways. If you go into a nursing home, you own a home, and you are not going to be able to go back to that home, then the Medicaid will put a lien on your home. Okay. If you pass away after being in the nursing home and on Medicaid, they'll also put a lien on your home in that case. And placing a lien means they're basically going to file a formal creditor claim on the title to your house. Now, just like I said, if you have a spouse living in the home, a child under the age of 21 living in the home, or a disabled child of any age living in the home, then Medicaid will not immediately initiate any kind of foreclosure on that lien, right? They won't require you to sell the house. But if it's just an estate owning the home, they're going to say you got to sell the house and pay back that lien. So that is something we try to avoid. And there are some ways to kind of do that. And we'll talk a little bit about how we avoid that. But again, most people receiving Medicaid, they can't have assets like in a bank account, right? You can't have more than $2,000 sitting in a bank account in your name and still be eligible for Medicaid. So that's not as much of an issue usually as the home place. So that's something we usually kind of focus on because it's important. Okay, going back, we talked about this briefly, but I just want to emphasize that joint assets are still going to be eligible for estate recovery. It's just going to be whatever interest the Medicaid beneficiary has in that joint asset. So if it's two people, then it would be half, right? So whatever their interest is. That can also be avoided in certain circumstances. So when you're doing estate planning in general, something we are always asking people is, how are things titled? Because understanding who is on the bank account, who is on the house, and then making sure that you're addressing that in kind of the worst case scenario situations, you're just kind of thinking about it, that's going to be a game changer potentially. Okay, so before paying Medicaid back, you get the letter saying, okay, you owe Medicaid this much money. Before you pay them back, there are some things that you can pay out of the estate. So the first and kind of important thing, I'm just looking at the questions really quickly, and I wanted to note, so somebody mentioned stable accounts. I'm going to talk a little and just briefly about how to kind of get around the estate recovery. So I'll talk about that. Stable accounts and able accounts are the same thing, and we'll talk about that briefly. They don't avoid recovery, so that's something I'm really glad that you brought that up, because we'll talk about that. In the meantime, before we talk about how to avoid estate recovery, I want to complete this part of it, and we're talking about what can you pay back before paying Medicaid back. One possible way to kind of mitigate estate recovery is a year support petition. So Georgia has a function called year support that a surviving spouse or minor children of the decedent can file. This is a fairly complicated legal filing that I would recommend getting some legal advice on, but it's also not so atypical that you can't potentially work with a court clerk to get the petition and kind of see what you can do with it. Year support is a function that allows literally for a year of support, again, for the surviving spouse and minor child of the decedent. And the way that looks is that you can file the year support petition and transfer assets from the decedent into the surviving spouse's name. And that can be really handy, because you could potentially just move all the assets into the surviving spouse's name after the fact, and not kind of avoid estate recovery. The only caveat there is that you have to notify a decedent's creditors when you file a petition for year support. Of course, Medicaid would be a creditor. So you would have to notify Medicaid that you're filing this petition. If Medicaid got its act together and submitted an objection to the petition, then it may not be quite as clear cut. You may not be granted year support. So, but it could be an option. The other thing that you can pay before paying Medicaid back are funeral expenses, with the caveat that some people have a burial exemption account that they're using that's not a countable resource when we're talking about Medicaid eligibility. So you're allowed to have up to $10,000 set aside for burial expenses. And if you have that, you can't pay the funeral expenses on top of that $10,000. But if you don't have the $10,000 set aside and funds came into the account because the person passed away, you could pay up to $10,000 in funeral expenses. You can also pay the necessary expenses of administering the estate. And that would just include, a filing fee for a year support petition, paying for the lawyer if you needed to hire a lawyer, things like that. You can pay the reasonable expenses of a deceased person's last illness. So maybe if there's a caregiver that's owed some money, something like that. And then of course, good old government, you can always pay the taxes that are owed to state or federal government. Okay, so somebody mentioned the able accounts, which is also known as a stable account. They're interchangeable. It's very important that we talk about special needs trust in relation to estate recovery, because they factor in. So when we're talking about special needs trusts, which are not able accounts, I'll get to able accounts briefly in just a second here. Special needs trust, you've got a first party special needs trust and a third party special needs trust. course, we're here today with the ARC of Georgia. So it's important to note that you can have first party special needs trust and third party special needs trust in pooled trust form, right? So you can sign on to the ARC or another pooled trust as a first party or third party. You can also have your own individual trust and have an individual trustee in first or third party. The difference between first and third party trusts are this. First party trusts are funded with assets belonging to the disabled person. So assets belonging to the Medicaid beneficiary, okay? So the examples of that would be like an inheritance. Somebody gets an inheritance, so we move it into a first party special needs trust, so they can still take advantage of Medicaid and Social Security benefits, but they can also take advantage of that money, and they can hopefully maximize quality of life and not be as much of, not necessarily have to rely on their benefits alone for their care. That's a common one, an inheritance. Another one is when people get settlement from a personal injury, lawsuits, things like that are very common things that we fund first party trusts with. The deal with first party trusts, okay, first party trusts aren't subject to estate recovery, but very importantly, they are subject to recovery, okay? It's just that they're not within the estate recovery scheme. They have their own recovery scheme. So do ABLE accounts, okay? So ABLE accounts and first party trusts are going to be, you're going to have to pay back to Medicaid whatever is remaining in the trust up to the amount that Medicaid spent on the beneficiary. And then anything remaining in either of those types of accounts would be distributed out according to the trust terms or the ABLE account designations, okay? So when people think of special needs trusts, I think they think a lot like, oh, okay, I can move my money in. Likewise with an ABLE account, perfect, I can start moving my money in. They're very good tools because they allow a person to maximize their benefits while maximize their funds while still being able to take advantage of benefits. But they do have that recovery provision. Remember, with estate recovery, the first $25,000 is just not subject to recovery. In the case of a first party trust or an ABLE account, that doesn't apply. When you're signing up for these programs, you're saying, okay, I really want to be able to take advantage of this money that I have, so I'm going to move it into these accounts, but I'm agreeing that when I pass away, Medicaid is going to send me a bill, basically. Okay, and so again, they can only send you a bill up to the amount that was spent on you, and in the case of ABLE accounts, it would be only the amount spent on you after the age of that you signed up for the ABLE account. So if you were disabled from a very young age, but you only just recently signed up for an ABLE account because they're relatively new, then it's only up to the point of time that you signed up for an ABLE account. That's a first party trust or also ABLE accounts, okay? They have their own recovery scheme. So it's very different from estate recovery because you're agreeing to recovery when you do a first party trust. I'd also like to point out, because I think it's important to note, that we also do third party trusts, okay? The difference between first and third party trusts are that third party trusts are funded with assets owned by anyone other than the Medicaid beneficiary. So parents who have a child with a disability will set up a third party trust. Likewise, a spouse could draft, we could prepare a will that sets up a third party trust that will benefit the surviving spouse. So someone other than the beneficiary's money is funding the third party trust, okay? That distinction is very important because Medicaid basically feels that they can't claim those funds because they're set up by another person with another person's money. So technically, we as people can decide what we want to do with our money. If we want to benefit someone with a disability, that's fine, but that doesn't mean that Medicaid can just now take claim to those funds. So that's an important kind of planning consideration when we're thinking about estate recovery, is that as much as possible.
I'm sorry. Sorry, I just see there's a question there. I don't want us to get too far off of that. Linda Blackwell asks, with that, is there the age of 55 on the recovery for first party?
Right, so the scheme for first party trust is not the same as Medicaid Estate Recovery, totally separate. So when you're setting up a first party trust, regardless of age, regardless of the amount of money in the trust, you're agreeing that any amount of money remaining in the trust will first go back to pay Medicaid if there's anything to pay, and then it will be distributed out. So when you're thinking about all the rules that I've gone through with Medicaid Estate Recovery, those don't apply to a first party special needs trust. Instead, when you're signing your trust, we have provisions in the trust saying that the trustee of the trust, the person who's managing the money, has the obligation to notify Medicaid when someone passes away, and then to make sure that the trust funds first go to any recovery that Medicaid wants. And again, that's only up to the amount of money that was spent on the person's health expenses. So Medicaid can't just say, yes, I want $1 million, right? You know, they have to provide an accounting, and then you can say, well, here's how much money we have in the trust. Here you go. Or here's how much money we have in the trust. We'll pay back Medicaid. And then if there's any money remaining, it goes to however the trust terms dictate. Likewise, with an ABLE account, it's important to point out an ABLE account can be funded by first or third party money, okay? But even if third party money is funding an ABLE account, it's still subject to that recovery, that automatic recovery. So it's just an important thing. ABLE accounts are a great tool, but when you're working with all of these different things, it's really good to know what you're dealing with. Okay, so that's the special needs trust. Totally separate from estate recovery, still very important to understand, because a lot of people think that they can totally bypass recovery in general with them, and you can't, unless you're doing a third party trust. Okay, so the question that people really want to know is, can I avoid estate recovery? And I want to be real clear, when we say avoid, it's not you know, some dark and mysterious world where we're evading the law. These are all very much blessed by the law and ways around dealing with Medicaid and estate recovery. So these are the main, on this slide, these are kind of the main options available, although it's very circumstantial and it can kind of depend on what's going on. One of the more obvious ones is transfer to a spouse. So when you're married and one of the spouses, let's give the example of nursing home Medicaid. A spouse needs nursing home Medicaid. To be eligible, we're looking at the spouse's assets together, but two spouses can have countable assets valued up to about $130,000 if one of the spouses is not receiving benefits. We call that spouse the community spouse. So if a spouse is out in the community and another one is in the nursing home, they can have $130,000 or so, it's about, together. So if you've got joint bank accounts, for example, you could just transfer the account to the community spouse. If you own a home together, you could just transfer the title of the home to the community spouse. That's assuming that the person in the nursing home can sign off on that, or they have a really good financial power of attorney. So the financial power of attorney is a big piece of the puzzle and all of the planning for estate recovery and things like that. Something to make sure that you have that and you have a good one, because it can be very, very handy. Because again, most times when people are in a nursing home, a lot of the time, unfortunately, they don't have the competence to sign a deed, you know. So, but you can transfer to a spouse, and there's no penalty or issue with that. Again, up to $130,000. That's an important one, and it's $130,000 of countable assets. So that's also something to note. Along those lines, you can also execute a will with a special needs trust, and it would be a third party special needs trust. So if you've got a situation where you think your spouse may need benefits at some point in the future, or you just know somebody who needs benefits and you want to benefit them with your own assets, you can have a will prepared. I would have a will prepared that has a special needs trust in it. So giving the example above, where we've got, let's say we've got John and Jane who are married, and we'll put John in the nursing home because men typically pass away earlier than women. So we'll put John under the bus there. And so John's in the nursing home, and maybe he's got Alzheimer's and he's going to be there for a long time. So he needs nursing home Medicaid. But Jane wants to make sure his quality of life in the nursing home is good. So she can do a will, leaving him any money that they have as a couple to a special needs trust. Because it's Jane's money and Jane is not receiving Medicaid, and it's Jane's money funding that trust, it's going to be a third-party trust. Okay, so it's not subject to recovery. So John can benefit from that money. And then upon his death, if there's anything remaining in the trust, it can go to whoever Jane wanted it to go to. So oftentimes when couples in our office, when couples come in, that's a really great kind of mitigation tool. It doesn't necessarily directly avoid potential estate recovery because you're kind of planning for down the line when you're signing a will, but it's a good option. It's something that I also recommend both spouses do because nowadays, so many of our folks who are caregiving for people, it's hard. And so they are, sometimes they're passing away sooner than the person who is receiving benefits. And so we want to make sure that person has done all their planning so that if the person receiving benefits accidentally inherits, they're doing it in a way that doesn't mess up their benefits and doesn't accidentally subject an asset to estate recovery. Another option to avoid estate recovery is transfer. Okay, so you could transfer to a trust. These are different than special needs trusts. We call them Medicaid Asset Protection Trusts or Medicaid Qualifying Trusts. So you could transfer to a trust, a family member, or a friend. And you can see, and wait out the 5-year period. It's very important that you understand anytime you gift to anyone other than a spouse, Medicaid is going to see that as a gift subject to penalty because they're going to say you could have been using that money to pay for your care. So if you transfer, that creates a gift. And when you apply for Medicaid benefits, you have to report any gifts that you've made in the past 5 years. So you want to make sure if you're doing any transfer, you have some time. So that's why it's good to be thinking about these things a little bit earlier rather than later, because you can usually protect all of your assets if you do that transfer in such a way that gives you a little buffer of time before you are going to need, let's say, nursing home assistance or something like that. Another option for transfer is you can transfer assets to a disabled child and not take a penalty. Okay, so it's not considered a gift, a true gift, if you're transferring to a disabled child, because the idea is that the disabled child will also need funds for care and so forth. It's important to know that you have to transfer assets properly to a disabled child. Of course, we don't want to just give them a bunch of money because that would potentially disrupt that child's benefits. But there are ways to do that so that you can get the money out of your name for purposes of estate recovery issues, and you can also not interrupt a disabled child's benefits. Another option that's perfectly acceptable is to just spend the funds down before going into a nursing home. And so a lot of folks don't, just like most everybody, don't really want to go into a nursing home. And maybe they don't necessarily qualify for some of the waiver programs because they have too much money. So an option is to just pay a caregiver to come in the home or otherwise spend down funds on yourself, right? So if you're trying to become eligible for Medicaid, you got to spend the money on yourself. You can't give it away, but spend the money on yourself until you become eligible for Medicaid, and then you can utilize benefits. And you've used your money. You've hopefully maximized your quality of life, and you have avoided the money just going back to the state. And the last thing I think is especially important to note, since we're here with ARC, is that you can use a pooled special needs trust, right? So you could set up a first or third party, well, in this case, it would be a first party trust, and you can elect any remaining funds in a first party trust. Instead of going to Medicaid, it can go back to the pooled trust. So you're not necessarily getting to leave it to family members, which is, I think a lot of people are really trying to preserve inheritance. But with the pooled trust option, you're still leaving it to a nonprofit. It's usually a pretty good cause. And so that's another option that's available to avoid having to deal with Medicaid. that's the end of my presentation. I'm certainly open to questions. We have a question. So somebody's asking, when you say transfer to a family member, I'll go back to that slide. When you say transfer to a family member, if you really sell your property to a non-disabled son, so if you actually sell the property is what it sounds like, is this affected by the 5-year penalty? And no. If you have a home place and you sell it for fair market value and you get money and you have to prove it was fair market value, and then you get cash from the sale of the house, that's not going to be considered a transfer subject to penalty. Very important to note though, if you sell your house, then you got a lump of cash. And so, you know, that's something to be aware of, because of course, in order to be eligible for these benefits, for the vast majority of these benefits, you've got to have $2,000 in countable assets to your name. So in some ways, it's a lot easier to work with cash. In fact, in most ways, planning to avoid estate recovery is much easier to deal with when we have cash as opposed to real property, because then we're just sitting on a house. So it's an option but if you are selling to anybody, you got to sell it for fair market value. Or if you're like, if you are loaning to someone, as long as you have a legitimate loan with some specific terms, that certain loans have to have specific terms to be eligible for Medicaid, but you can loan money as long as it's a legitimate loan under Medicaid qualifications. But again, that doesn't really achieve the purpose of avoiding estate recovery, because it's going to be coming back into your name and going to the nursing home. Any other questions? Let's see, I'm going to stop sharing my screen. And okay, I know that was a lot of information. We will, a couple of you asked about sharing the PowerPoint, so I will be sending that over. And you know, I'm also, okay, let's see, one more question. Oh, sure. Somebody asked if I can put the contact info back up. Let me do that. Share screen. And let's see. I'm going to share my PowerPoint. Yeah, share. And then let me scroll down to the last page there and make it a, whoops, there we go. Okay, we had some questions while I was doing that. So let me get back to the chat box. Somebody asked for a Social Security recipient that obtained Medicaid through the Social Security program. Is that individual subject to Medicaid recovery? Probably not, but again, it depends a little bit on what kind of Medicaid people are receiving. If you're just receiving the very traditional kind of healthcare Medicaid through Social Security, then no, you're not subject to estate recovery. Okay, and then someone said special needs trusts are exempt, question mark. And third-party special needs trusts are exempt from any kind of recovery. So any kind of recovery that is either in general, you are exempt from that if you have a third-party trust. Again, it's got to be a qualified special needs trust, and it's got to be funded with money other than the disabled person, and you cannot intermingle funds. So that's kind of important to know. But the third-party trusts are exempt. Again, remember, first-party trusts and ABLE accounts are not exempt from having to pay back Medicaid. They are exempt from estate recovery because they have their own recovery scheme. Okay, I don't know if there are any other questions, although they may be kind of trickling in a little bit. I'll just kind of hang tight for just a minute or two, I suppose, and then we can finish it out. I hope everybody enjoys this nice day. So somebody's asking, so ABD Medicaid is subject to estate recovery. It depends on the kind of ABD Medicaid you're receiving. If you're receiving waiver programs are qualified under ABD Medicaid, as is nursing home Medicaid. Again, this is complex stuff. This is kind of a survey of all of this, and I would recommend if you have questions about this, certainly you can call our office. There are several other very good special needs planning attorneys in the Atlanta area, for Georgia at least. What you're looking for when you're looking for a lawyer to call on this stuff to get really specific details on your case is it a special needs attorney, someone who has some deep familiarity with benefits. Somebody asked, what is ABD Medicaid? That's aged, blind, or disabled Medicaid, and it's a overarching category of Medicaid for anyone who's aged, blind, or disabled. But there are several programs under ABD Medicaid. Okay, so somebody asked, it's the same person asking about, is the special needs trust exempt? And they have, just to give an example, they have a special needs trust that's funded by their parents' life insurance. Assuming that trust is drafted properly, again, that's sometimes a little bit up for grabs because this is kind of a niche area of planning and some lawyers dabble a little bit. Assuming you have a properly drafted and it's properly executed and administered special needs trust, that would be a third-party trust because it's funded with someone else's money. So funded with parents' life insurance, third-party money going into a third-party trust. Somebody's asking, is TEFRA included in recovery? I don't believe so. I'm not 100% sure on that, but I don't believe so. The primary programs that are subject to recovery are, well, let's see. I'm not 100% sure of what TEFRA is, although if you can clarify for me, I think that that is related to low-income Medicaid, but you can confirm that if you want to. I don't think it is though. The primary programs that are subject to estate recovery are going to be the waiver programs and nursing home Medicaid. TEFRA is not a waiver program. All right. Let's see. Oh, Dominique is, so also something just to note, folks, is that Dominique is putting she's summarizing my answers in the chat box. So if TEFRA is a Katie Beckett waiver, then no, it's not subject to Medicaid recovery, because that would have, if that person started receiving a different kind of waiver once they hit 18, and then they were continuing to receive waiver services when they were 55, after 55, it's subject to recovery. So there are all of these questions are kind of going in, little summaries are going in the chat box. So that may be handy information for you to see. Okay, let's see if we get any other questions, and then I think we'll wrap it up. Okay, so I think we'll kind of wrap it up from here. Again, you've got my contact information, and we'll be sending out the slides. And I hope everybody got something out of it, and maybe not enjoyed, but at least felt like it was a productive time spent.